Good day to you and welcome to another Paddocks Club tutorial. Today I want to give you an overview of mediation or conciliation. These are two terms which you're going to hear a lot more about. So let's start off with looking at what are these processes. Well, they are what is known as alternative dispute resolution processes, and they can be compared to negotiation. In fact, one of the best definitions is assisted or facilitated negotiation, and they can be contrasted. What they're not like is arbitration or litigation, in which case a third party comes in and makes a decision for the parties. The terms are often used to refer to the same process, and there are variations. You're seeing mediation or conciliation come into many aspects. It's not only in labor law, it's in consumer law, in all sorts of things that one is seeing this coming into South African law, and it's something that managing agents are going to have to get used to. A neutral person skilled in facilitating settlements works with opposing parties to assist them to find a mutually acceptable solution to their problem. That's the fundamental. So what is the essence of this process that I've described in the abstract? Well, we start off with the parties agree, or perhaps they're obliged to participate in the process. It might be a required step before you move on to arbitration, adjudication, or litigation. The process is informal. It can be conducted by telephone, it could be conducted by post, it could be conducted in person. It's therefore less intimidating than either arbitration or litigation. The parties know that they can control the process. They can't be forced into any agreement, as they might be in arbitration or litigation. It's often said, and there's a lot of truth in this, that the mediator's strength is in fact his or her weakness. He can't twist your arm. He can nudge, he can cajole, but he cannot force you to do anything. The neutral, as the person is known, never takes sides, doesn't judge the parties or their behavior. That's not their job. Their job is to facilitate an agreement that the parties buy into. Diplomacy and negotiating skills are brought to bear to guide the parties to what they consider to be a mutually acceptable solution. So, okay, that's fine, but what does the conciliator or mediator actually do? Well, in practice, the first thing is to establish ground rules for respectful conduct. This is how we're going to talk to each other. We're not going to scream or shout or hit each other. We are going to behave in this way. You get the people's buy-in to that as a first step. You then structure and manage the conciliation process. You help to clarify the facts and the issues. You allow people to hear one another talking to each other or see what they've written, so that you get some true communication actually going. Very often in negotiation it's a whole lot of shouts. There's very little actual communication. The neutral helps the parties determine what they need out of the resolution and helps them to generate options that might be acceptable to them to resolve the dispute. The neutral keeps lines of communication open and the discussions on track, and acts as a sounding board, an innovator, and a reality tester. So they say, oh, well, we'll just change the rules so that this won't happen again. Well, can you? I mean, are there not other factors involved? Don't you need to get the body corporate's agreement to that? So this is the reality testing. Will this actually work, this thing that you're proposing? What documents might be involved? Well, there could be quite a lot. Very often these things start with an exchange of suggestions to find a mutually acceptable conciliator. Before the conciliation begins, it might be in a non-obligatory conciliation or mediation that the parties sign an agreement setting out how it will work, who will be paid what, and so on. And sets out the rules and procedures to be followed. The conciliator may also want to arrange for an exchange of certain information or documentation. If he feels that one person is sitting on something that the other doesn't have, and it would make a difference to the other person's attitude if they did have it, then the conciliator may ask for a short summary report or some documentation and ensure that there's an exchange, a bit like the discovery process in litigation. The conciliation process then continues until all the issues are resolved, or until some or no issues are resolved and the conciliator feels that it would not be productive to continue. If you've got two people who simply don't want to talk, won't cooperate, won't communicate, then the conciliator, being a party to this agreement, can say, I'm sorry, I've had enough, that's it, I'm not going to waste my time further on this, and that's the end of it. I've tried my best, it isn't going to work. Now, if some or all of the issues in dispute are settled, and I might just say that in general terms the settlement rates are pretty high. In other systems overseas, in the 80s and 90% of disputes can be mediated or conciliated. But let us say that some are, and some aren't. Well, those issues in regard to which there is an agreement that's written and if down and signed by the parties so that they can't walk away from that at a later stage. There's commitment, in other words. You buy into the agreement by signing a document. If you're in the middle of court processes, it might be better to have a consent order in regard to those issues, or perhaps all of the issues that have been decided. So let's have a quick overview of a typical process. You start off, the conciliator makes a short opening statement, explains the process, reviews the ground rules, and the agreement to conciliate, or the obligation, describes his or her own role in the process and that role of the other parties. The conciliator gives each party an opportunity to describe what they think needs to be resolved. In other words, what are the issues? And then the conciliator works with the parties to clearly identify. So we're now all absolutely clear. These are the issues we need. We're not going to change them later. For the purposes of this conciliation, these are the things we're going to sort out, or try to sort out. The conciliator then helps the parties to develop goals for the conciliation, individual goals, incorporating their needs and their interests. What will make this go away for you? The parties discuss the issues one at a time and identify options for resolving them. The conciliator helps and assesses, analyzes the options, but doesn't ever take sides. At some point during the conciliation, the conciliator may want to meet separately with individual parties to the dispute in what they call a caucus, and the parties can break at any time to go and talk to their attorneys or anybody else. So that, in general terms, is an overview of this entire process. I hope that this has been of use to you, and you're very welcome to ask further questions in the discussion forum.